Hello and welcome to Williams Mullen Trending Now, an IP legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Ed White, and today I'll be joined by my partner, Janet Cho, who is also a teammate of mine in our intellectual property practice here at Williams Mullen. We'll be discussing how to enforce and expand your brand during the COVID-19 pandemic. Janet, how are you doing today?
I'm doing well, Ed. Every day is a good day in brand world. How about you?
Doing very well. I'm excited to talk about our topics today because I think a few of them are things that people might not typically think about other than maybe in a pandemic. Starting with, I think, how trademarks can and can't be used and maintained. So without further ado, let you kick it off and talk a little bit about excusable non-use.
Yes, so thank you. This is a bit of a pet topic of mine. So as you all, I think as our listeners know, when you have a trademark registration, at certain points in the life of the registration, you have to renew it, typically at the 5-year anniversary and then at the 10-year anniversary, every 10 years thereafter. And as part of your renewal, you have to show that you're using the mark. You have to attest to that, and you have to show proof of use through what we call a specimen. And so during COVID-19 times, it's very possible that as a trademark owner or trademark registrant, you haven't been able to use your mark, say, because you were in a jurisdiction or you run your business in several jurisdictions where you're under, say, stay-at-home orders, or your business was forced to close. And so in a circumstance like that, what do you do? How do you prove non-use if for the past several months or maybe the past 3 months you haven't been allowed to, say, operate your restaurant or sell your goods or services? So the United States Patent and Trademark Office does allow you to claim something called excusable non-use, which is something they allow at the time you go to renew your registration that says if, one, you haven't been using your mark due to a circumstance beyond your control, then we may be, the office may essentially excuse that non-use. So the flip side of that is typically when you go to renew your registration, you should have been using your mark consistently for all of the time leading up to that renewal period. So under excusable non-use, the USPTO will essentially allow you to have a period of non-use that it will, like the doctrine says, or the statement says, is excusable. However, it's a relatively high bar, but it may be something that a registrant may want to avail themselves of during this time. And you have to show, one, that the non-use was beyond your control and that you've made some effort to try and resume use. So one example might be that, if you were forced to, under your state's orders, to not open your bar or restaurant, what I would recommend is you provide as much detail as possible at the time you go to renew your registration of what exactly happened, what were the circumstances, and then make clear that it was as a result of the order from your home jurisdiction, and then also explain what you're doing to try and resume that use. Under excusable non-use, if you have not used your mark for a period of 3 years consistently and you have not done anything to resume use, the USPTO will make a presumption that you've abandoned your mark. So certainly not doing anything affirmatively to restart your business is not going to be helpful, but you certainly want to do as much as you can if you're able to try and resume. So even if your business is closed, if you're still staying in contact with your suppliers and still trying to prepare for reopening, those may all be helpful. I will say excusable non-use is very fact dependent and it's in the discretion of the USPTO. So I certainly don't want to convey that it's something you automatically get if you claim, but I think the more information that you have, the more evidence you have that something was completely beyond your control and that you're doing in good faith what you need to do to restart your business, I think those are all more helpful than not in terms of claiming excusable non-use. And, one thing I would say is if you think you can avail yourself of excusable non-use, to definitely try and gather the information that you have, because you've likely invested a lot of time and money in getting your registration and maintaining it. And there is a lot of monetary value to your registration, and you don't want to give that up if there's an opportunity to keep it. So with that, on that note, the topic of, or the subject of, monetary value of your brands, I know, Ed, you've spoken at great length about monetizing IP, monetizing your brands, and it may be helpful if you spoke, sort of on the flip side, or another aspect of the monetization or the value of IP or brands, I should say.
Yeah, no, thanks, Janet. And the excusable non-use is really pretty darn interesting when you consider the shutdowns we've had and how it's not typically something we'd be too concerned with. But I appreciate your comments on that, because I think it's something that trademark owners really are going to have to deal with going forward, especially when they go to renew registration. So yeah, back to monetization. I kind of look at this as, I think we all try to find the silver linings as best we can in the pandemic. And I suppose one of those silver linings could be that you might have an opportunity now to monetize your IP and potentially even expand your portfolio. So let me tell you what I mean by that. I think that there are a number of businesses right now who have some financial distress, in large part because they are shut down. And if there was ever a time to potentially sell or license your IP to offset some of the liabilities you have currently, certainly now is a good time to explore that. And so if there are other entities or individuals and parties out there who have asked you in the past about purchasing some IP or a trademark, or have been interested in licensing the use of a trademark, I think it would be helpful to perhaps think about revisiting that at this point, because even though there are some shutdowns in the works, people may be of the mind that they would like to expand their portfolios. And on that point, if you are one of those people or parties that would like to expand your portfolio, again, a silver lining might be that there's an opportunity to obtain a trademark or some IP to help another company that might be in financial distress. And I'll just give a quick example of that. We represent an international client who several years ago was thinking about using a particular trademark. They ended up in a somewhat informal dispute with another company about that, and ultimately decided that perhaps they would move off of the mark and onto a different mark. But their internal business people never really got over that. They really did like the initial mark that they were hoping to obtain and use. And so as part of their strategy during the pandemic, they decided they would go back and perhaps see if some of these marks that they've been interested in the past might be available now, whether or not they've been canceled, et cetera. We approached the other party in this situation. They felt it was an excellent time to sell all their right, title, and interest in that trademark, along with several domain names that our client will now be able to use. And so we actually had a very happy outcome for the client as far as obtaining a mark that will expand their portfolio. And obviously, I suppose on the flip side of that, if you are the party that was selling that trademark, you were able to obtain some financial relief by selling your IP asset. So I would just remind our clients that now is an excellent time to consider that as they look at their overall portfolios, as they look at the maintenance of those portfolios, and again, the potential expansion of those portfolios. So with that, Janet, let me kick it back to you, because I just mentioned maintenance of portfolios. There's also some interesting facets on that point right now. Obviously, clients can't forget about maintaining portfolios, even if they're closed down. But tell us a little bit about what clients should be thinking about during the pandemic as they enter into some of the maintenance arrangements that they need to complete.
Yeah, I mentioned some of the milestone renewal dates, at least in the United States. But as you mentioned, when you have at least a trademark registration, there are going to be some deadlines associated with that, both in the United States and maybe in other jurisdictions in which you own registrations. And so I know that in other realms of life, we're all getting some relief on deadlines. So maybe tax deadlines and rent and all of that. And I will say that the United States Patent and Trademark Office, as well as other trademark registries around the world, have relaxed certain standards, have granted certain extensions, maybe even granted some relief regarding fees. And I think that's great. And I think if you need to or can avail yourself of that kind of relief, it's very helpful. However, the flip side of that is, even during these times, I would say don't assume that you're going to be relieved of your duties to maintain your registration, whether it's here in the United States or elsewhere, and stay on top of your deadlines. Because one, if you miss that deadline, you yourself are potentially going to invalidate that registration that you've worked so hard to obtain and get. And also, to your point, once that registration is invalidated, if you had some plans to potentially license that mark or maybe sell it because it's an asset in your portfolio that no longer has the value that you once ascribed to it, well, letting the registration lapse is certainly going to affect the value that someone's going to pay for that registration. So I think in all of this, I would remind everyone to check your deadlines, make sure you're meeting your deadlines, and don't assume that your deadlines are relaxed simply because we're in COVID-19. Now, you may be getting some relief, and I think it would be helpful for you to check to see what relief you're entitled to, if any, but certainly maintain your deadlines and stay on top of your deadlines. And I know that we here at the firm have a resource within our COVID-19 assistance program where we're keeping track of which jurisdictions are offering what kind of relief or what kind of extension deadlines or fee relief. So if you have any questions, feel free to reach out to Ed and I, because it's something that we can share with you. It's certainly information that we can make available if you have questions. I realize if you have registrations in many jurisdictions, you're not going to be on top of whether or not, what kind of relief France is offering. It's not top of mind. So it's definitely information that we can share with you or help you get if you have those kinds of questions. So, and maintenance is very important, because if you drop that deadline, it's pretty final in terms of renewing or maintaining your registration. So, Ed, I'll also turn it to you. I don't know if you have any helpful hints or parting words regarding maintenance of registrations.
Yeah, no, thanks, Janet. I think you really tied it up well. I mean, I think the key theme there is keep your eye on the ball. I don't think that we can, even though there is some forgiving of deadlines, some expansion of deadlines, at the end of the day, I think clients do their best to keep on top of the specific deadline. And as you said, if it's a particular jurisdiction where we can take advantage of extensions, et cetera, we are happy to help advise them on that. And I think we've done a nice job of putting together that database you talked about. So if you're listening to this podcast, by all means, if you have U.S. And international filings, we're happy to assist in that regard. Well, that will wrap up our discussion about enforcing and expanding your brand during the COVID-19 pandemic today. I'd like to thank Janet Cho for joining me on the Trending IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find more about our team, as well as past episodes of this podcast and our legal alerts, which can be very helpful. Be sure to subscribe to this podcast to be notified when our next episode posts. And thank you very much for listening. And until next time, this is Janet Cho and Ed White. Thank you.
Thank you.